Chattels are objects which do not belong to the land. They might be on the land, but they're separate from it. So a car parked in a driveway is not somehow part of that house block. Other objects, for instance a rotary clothesline, are connected to the land and they become part of the land. The distinction is important because it changes the rights of the owner of the object. In this case, developers were developing two properties in Melbourne. They engaged Barlin Scott Air Conditioning to install two industrial-sized rooftop air conditioners capable of cooling the whole building. These air conditioners sat on the roof on top of vibration-absorbing pads. They were only connected to the building by an electrical connection and a hose secured by 4 bolts, which could easily be undone. The air conditioning contractors had difficulty getting paid. Eventually, they removed the air conditioning units and stopped work. The building could not be put into operation. The developers sued, saying the air conditioners were fixtures, part of the building, and therefore not something that could be lawfully carried away. The court had to decide if the air conditioners were fixtures or chattels. Justice Kay cited the conventional rule that whether the annexation of the plants was sufficient to constitute the plants fixtures must be determined by the circumstances in which the same were positioned on the platform, and more particularly the intention as evidenced by the degree of annexation and the purpose of the annexation. Justice Reed then focused on the second of these, saying, whether the intention of the party fixing the chattel was to make it a permanent accession to the freehold is to be inferred from the matters and circumstances including the following: the nature of the chattel, the relation and situation of the party making the annexation vis-à-vis the owner of the freehold or the person in possession, the mode of annexation, and the purpose for which the chattel was fixed. Because the air conditioning units were fixed to the building even slightly, they were presumed to be fixtures, and the air conditioning contractors had to prove that they had intended them to be chattels. They were unable to do this. Air conditioners are, after all, quite integral to an office building. The court found that the air conditioners, despite their flimsy connection to the building, were fixtures.